Good morning, all. This case management conference is in the matter of CFI 038-2025 and is being held by way of video conferencing before His Excellency Justice Thomas Bathurst, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Morgan, Lewis and Bocas. Lead counsel is Mr. Stuart Sanders. The defendant is represented by Altamimi and Company. Lead counsel is Mr. Gavin Mansfield, KC. Thank you, Your Honour.
Thank you. Good morning, gentlemen. You can take it that I've read the skeleton arguments and most of the cases, most of the material in the case bundle. So you can proceed on that basis, Mr. Sanders. I think it's your application.
It is indeed, Your Excellency. Thank you very much. I'm grateful for that indication. As you will be aware, the parties are agreed on most of the core documents for the case management conference, and really the sole issue of principle before you today is the application that we've made for a split trial, with then effectively some mop-up directions to be determined on the basis of that. On that point of principle, once that point of principle's been decided. My learned friend and I are also agreed as to the correct legal approach to adopt in relation to whether or not split trial should be awarded, and in particular the approach set out in the case of Jinxon and Asa Media in the English Commercial Court we suggest is the correct approach for this court to take. I accept that the burden, as it were, is on me to show that there's a real and substantial advantage in pursuing matters by way of a split trial, and that can be done by reference to the specific factors set out in Jinxon and Asa Media and that are referenced in my skeleton. In reality, it's just a matter of looking at the case as a whole, really essentially factors of common sense as to what's going to be the most proportionate and efficient way of dealing with the case before you.
Mr. Sanders, I must confess that over the years I've come to have the same degree of caution about split trials as Jeremy Cook expressed in the case cited by Mr. Mansfield. Can I tell you at the outset what concerns me about it? It would be highly attractive if that all that was involved was liability and a fixed sum under Article 122 of the Dubai Contract Law. The difficulty, as I perceive at the moment in this case, at least as the material presently stands, is first that the establishment of the amount due under Article 122 will require, whether you call it estimation or whatever, a degree of evidence to establish that sum. So you're getting into the damages question already. Secondly, to the extent that restraint of trade and penalties have been raised, Article 122 of itself provides for a reduction to an amount that is reasonable. Now, when you take those positions into account, there is a real prospect that there will be potentially a significant overlapping if a separate or split trial was to be awarded. Now, it's fine if you win. The problem is if you lose. The problem is if you win on liability and lose on 122, then you've got to put the two together. I just have some difficulty with it at the moment. I thought I'd tell you up front.
I'm grateful, Your Excellency, for that indication. I can tailor my submissions accordingly. Your Excellency raises three distinct questions where the defendant has indicated that they consider there to be overlap, and you've indicated that preliminary view as well. And the overarching response I would have to each of them is that the nature of the inquiry is a different one in each case, which limits the degree of overlap. But there are slightly different questions in relation to each. Firstly, in relation to the question of restraint of trade and penalty, which Your Excellency raises, in my submission, there's a clear temporal distinction between the nature of the inquiry that should go on in relation to those issues. So restraint of trade and penalty, in my submission, fall to be determined by reference to the position that existed as at the time of the contract being entered into. And that's when the court should assess whether or not, for example, my client had a legitimate interest in the matters it wants to pursue. Obviously,
Just to be direct, Dr. Ramon, I understand that principle. That's well established, but and I don't know the answer to this. Does Article 122 also look at it at the time of contract, or for the purpose of considering a reduction at the time of breach, or at the time of trial?
So in relation to Article 122, that I have to accept is a different position. There's not a lot of case law in terms of how the DFC courts address that particular question. I have to accept that I can't draw that bright line distinction in terms of Article 122.2 and the reduction that is. What I would say is the sort of inquiry which the defendant suggests should take place, i.e., that what you do is you determine actual losses in full, and then you apply once you've gone through that exercise and determined that figure, you apply a comparison between what that actual figure is and what the liquidated damages figure is. Then you compare that, then you see, is that grossly excessive? And then you apply the 122.2 reduction. I do say that as a matter of principle is the wrong way of going about things. It's a much broader brush exercise. If what the defendant's position were the correct way in which to approach the application of Article 122.2, its effect would be to denude liquidated damages clauses of a very significant part of their practical utility, in the sense that
only to the extent the clause was found to be unreasonable in its terms. Article 122.2 can't operate until that's been established.
Well, Article 122.2 provides for a reduction where the sum is grossly excessive.
So you've got to establish the sum is grossly excessive before you even get in that territory.
Exactly. But what the defendant appears to be saying is that in order to determine whether or not the sum is grossly excessive, what you do is you do a full damages inquiry, you find out what the actual damages are, and then you compare them to what the sum under the liquidated damages clause is. And you compare those two figures and you say, well, is one grossly excessive with relation to the other? And what I say that's the wrong approach, and it's a much more general and broad brush approach that the court should perform in determining grossly excessive. And in order to do that, there's no requirement to provide a precise figure in terms of what the actual damages are. Still less go into a detailed damages inquiry with the benefit potentially of expert evidence. I say that grossly excessive, one, of course, is a high threshold, but two, it should be assessed by reference to the generality of the position rather than by performing a precise quantification exercise. And so I say that in this case, for example, it can be done certainly without the benefit of any expert evidence to determine precise quantification.
Yep.
Then thirdly, the third point you raised is the fact that the sum that we're seeking in terms of the liquidated damages clause requires, as we put it, some estimation in terms of arriving at the correct figure. Now, there are two distinct points that the defendant seeks to raise about this. The first is they say it doesn't make this makes this not a specified sum, and therefore not falling within the ambit of Article 122 at all. That's obviously a point that we will have to deal with, but I do say that's a distinct legal point, which turns on the question of legal submissions, and therefore shouldn't affect the question of whether or not a split trial is necessary, because it can be dealt with separately and without the benefit of detailed evidence. The second question, which I fairly and squarely have to deal with, and is the one in which I say there is some degree of overlap, and I have to accept that, is in relation to the question of what exactly that sum should be when assessing the amount of the bonus, and therefore the amount of the liquidated damages clause. Now, as I say, I agree that there is necessarily some overlap there, because it does require some estimation based on counterfactual events. Again, I say that the nature of that inquiry is a different one, and I say that in the context of a liquidated damages clause, the court should engage in what we describe as estimation, rather than trying to apply a sort of a mechanistic and detailed damages inquiry approach, requiring, as we say, potentially expert evidence. And there are ancillary points to that. The first of which is that it's a matter for us, we say, to prove the estimation and losses flowing in that regard, and we say we can do that by reference to an estimation-based approach, and we can do that by reference to factual evidence rather than by reference to expert evidence, and we can proceed in that way in terms of how the bonus element shakes out of the liquidated damages clause. The second point there is we have put forward there are two elements of bonus. There's we say a mid-year bonus and an end-of-year bonus. Now, there's a dispute about whether or not there is truly a mid-year bonus, but that again is a construction issue which can be dealt with easily in the first trial. In relation to the end-of-year bonus, there is a specific contractual trigger of a figure of £4 million worth of revenue, and therefore we say that the type of precise estimation that would be required for an actual damages inquiry is not going to be needed. What the court will just need to do is make a binary decision about whether or not that trigger would have been hit, and again we say that's something that can be done, and we are prepared to and propose to prove by reference to factual evidence only. The mid-year bonus doesn't have that same contractual trigger. However, the manner in which it's pleaded, is by reference to specific contractual targets, which we say are conservative and were set in place before the contract was terminated by us, I should say, determined by us before the contractual target was before the contract was terminated. And again, we say we can prove that target, which we accept would be the limit of what we could claim, again can be proved by reference to factual evidence, and therefore a split trial would save the need for expert evidence, and there's no prospect in my view that in my submission that we would need to have an overall longer sitting time, for example, to deal with any small points of overlap. The defendant suggests that a combined trial of this case would take 5 to 6 days. For what it's worth, we say that 5 days would be sufficient, but we say liability trial can be done in 3 days and a quantum trial could be done in 2, so there wouldn't be any duplication. And certainly if we were in 3 days and 2 days, we would be squarely within the DIFC court's practice in terms of sitting remotely in our submission, and therefore the factor of travel that the defendants rely on also wouldn't be duplicated. In fact, they wouldn't be. That in fact, I'm not. I don't know your practice, Your Excellency. We will be proposing that even a 5-day trial take place remotely, but I'm aware that the DFC courts are starting to move to some 4+ day as being in person. If that's the case, well then a 3-day and a 2-day avoids any.
I'd be sorely tempted to do it. It was a 5-day trial online, although I think that when it gets to a stage where the benefits online is more than offset by advantages. But I may make myself a bit unpopular with the Chief Justice if I do it, but let's leave that to one side for the moment.
So those are my submissions in terms of addressing the three.
Can I just ask you one thing for your consideration? What you're inviting me to do is to will inevitably involve an element of speculation as to the future course of this hearing. I don't know what evidence are going to be put on. I don't know what people. The pleadings of myself with respect very clearly define what's between the parties, but you're really not going to know whether it was a desirable order or otherwise until you see how the evidence emerges. And if I do it, it may turn out to be a good idea. It may not turn out to be a good idea. In that sense, I wonder if the application's a little bit premature. The disadvantage of putting that proposition is that I'll only find out after all the work's been done, so you lose the advantage of it in any event. But that is one thing that's worrying me, Mr. Sanders.
I can understand the concern, Your Excellency. The point you raise at the end of that section, I think is the relevant one. The danger, the reason why we say it needs to be done now, is in particular in relation to the expert evidence. We say a split trial, the first trial can proceed without expert evidence, and on both parties' primary case, that will be the end of the matter, and we will proceed to a final judgment in relation to the first trial, and there'll be no need for any expert evidence at any point. If we proceed on a single standalone trial basis at this stage, not only will the factual evidence, although I admit there's limited overlap, have to deal with both matters, which then becomes somewhat harder to disentangle. Given the timetables that the parties are proposing, there may be a pretty narrow window in which we could seek to come back to the court following witness evidence and say, well, we've seen how the witness evidence has shaken out. We remain of the same view that a split trial would be effective, and we want that ordered before we go and start dealing with expert evidence. We say that would end up delaying matters. So we do say the appropriate time for you to determine this issue is now, or at least we say that our application for it's not premature. To the extent that there's some speculation as to what the evidence will cover, to a degree, I accept that, of course. But as you say, the issues are clearly pleaded and well defined between the parties. The agreed list of issues. There's an agreed list of issues. I don't say that this case involves more speculation as to that than would be warranted in determining a split trial application.
Thank you. Yes, Mr. Vanson.
I'm grateful, Your Excellency. First of all, I don't disagree with what Mr. Sanders says, that now is the appropriate time to determine the question of split trial, because it is going to affect the shape of the directions and the evidence, and it's better for everyone to know now whether we're proceeding on a split basis or not. I do, of course, disagree with them as to whether a split is appropriate. And the two key problems with the application for a split is, first, the split can't really cleanly be identified in terms of the issues that are being dealt with at each trial. And second, it will inevitably lead to a duplication of evidence, and the same sort of factual issues are going to have to be addressed on Mr. Sanders' proposal at both stages of the trial, and that's going to lead to a duplication of evidence and some difficulties for the judge in deciding exactly what to find on the basis of the evidence they've got at the first trial, knowing there's potentially a second phase down the line. And now it seems from, I've listened carefully to Mr. Sanders' submissions, seems to me he accepts that at the first trial that he proposes, there will need to be some evidence to deal with questions, for instance, such as the estimation of the remuneration package that my client would have earned, and an estimation as to what the different factual elements that need to go into calculating the specified sum. And Your Excellency, I haven't heard him say that the scope of the factual inquiry at the first trial is going to be completely different to what would be necessary at the second trial. His point is, well, at the first trial, you're engaged in a more broad brush basis about estimations. And that presents a real difficulty if you've got some facts. Say, for instance, one fact is about revenue that would have been generated over the relevant calculation period. If the court's being asked to make findings as a matter of fact on an estimation of those things at the first trial, and then if we get to a second trial, it's going to have to come back and look at things again in a more granular way. Now, I say, and I'll develop this in a moment, Mr. Sanders' approaches to that estimation broad brush is wrong. But even if he's right, the problem that we parties have got to grapple with and the court's got to grapple with is, how broad is this broad brush? And sorry, to be less metaphorical, what evidence are we going to call? What detail do we need to get into? Once the box is open on a particular factual issue, well, we've got to go all in on trying to prove it or disprove it, rather than, it's not like a summary judgment application where you're trying to get over a hurdle, a low hurdle, or an interim injunction application. If there are issues at trial, we've got to try and prove them.
There is perhaps something unattractive about someone being able to have a go at a broad brush basis. Then if that doesn't work, come back and do it more formally.
Well, exactly, Your Excellency. So we say it's appropriate to do it in one go. And Mr. Sanders says, well, that rather defeats the object of liquidated damages clauses. But, Your Excellency, there are two factors in this jurisdiction and on the facts of this particular case. The first is Section 122, 1 and 2 are clear in the exercise that the court's required to go through. And the second is, in the facts of this particular case, the difficulties for the claimant in seeking to enforce what they call a liquidated damages is in the way they've drafted it. It's their contract, and it contains we say it's defective, but I appreciate that's a separate point. On its face, it contains a number of areas of factual inquiry one's got to go through to work out whether there is a specified sum and what it is. And if I can just develop those 2 points briefly in turn, Your Excellency, Section 122(1) says where a contract provides a party who doesn't I'll start that again, I misread it, I'm sorry. Where the contract provides that a party who does not perform is to pay a specified sum to the aggrieved party for such non-performance, the aggrieved party is entitled to that sum irrespective of its actual harm. Fine, so far so good. But in 2, there are 2 points I particularly want to draw your attention to. However, notwithstanding any agreement to the contrary, the specified sum may be reduced to a reasonable amount where it's grossly excessive in relation to the harm resulting from the non-performance and to the other circumstances. So, Your Excellency, there are 2 questions that subparagraph asks. First, in relation to the harm resulting from the non-performance, it doesn't say an estimate of what it might be. It asks the question, what is the harm resulting? from the non-performance? And that's a factual question that requires factual inquiry as to what actually the harm was. Second, reduced to a reasonable amount. How does one determine that without knowing what that harm resulting is? And it's interesting, Your Excellency, if you look at what the application for split is, and if I read the split trial application into the list of issues, the list of issues starts at page 95, Your Excellency, but the relevant part is at 99. At the top of page 99, you'll see the heading liquidated damages, and that the relevant parts are 9 through to 16. And there's a footnote to the heading damages just above 14. The claimant contends the issues under this heading should be delayed until a second trial. So 9 to 13 are in the first trial on the claimant's proposal, 14 onwards in the second trial. If we look at 12 in the first trial, is the sum under the liquidated damages clause grossly excessive under Article 22.2 and alternatively manifestly excessive under the law of damages and remedies? And 13, if so, should the court reduce the sum due, and if so, to what figure? So the claimant would have us try and determine at the first trial whether or not the sum is grossly excessive in relation to the harm resulting, and if it is, work out what the appropriate figure is. Now, that's impossible to do without all of the evidence that would flow at what the claimant perceives as a quantum trial. So that's the point about Article 122.2. My second point is about the way in which this liquidated damages clause works. And if I may, Your Excellency, I just would like to take you to the contract itself so you can see the complications in it. And the relevant liquidated damages clause is at page 31 of today's bundle.
Yep.
And it's paragraph 12, liquidated damages. It runs over to 13. And to an extent, one does have to wrap a cold towel around the head to get to grips with this. But if I can just walk through the pertinent point, Your Excellency, where you leave the employment of the employer without the consent of the employer prior to the expiry of the term of your employment contract, or after or is the relevant bit, you fail to join the employer in accordance with the terms of your employment contract. And we don't need to worry about the parenthesis 1, 2, 3, 4, 5, 6, 7th line. You accept and agree that the remuneration package as defined below, and then there's a calculation of some maths to be done, arithmetic to be done to the remuneration package. And on the penultimate line, will constitute a genuine pre-estimate of the losses that the employer will suffer arising from your departure, or in this case, failure to commence working. Now, I accept, Your Excellency, on this page, the maths that I skipped over is purely arithmetic. But the question is, what is the remuneration package, that defined term in the middle of the paragraph? And that is at 12.3 over at page 32. Remuneration package means the total amount of any of the following which are paid or agreed to be paid during the calculation period. And pausing there, calculation period is defined further down the page, relevantly for our purposes, 12.3.2.2, where you fail to commence working the first 12 months of the term. And if not payable within that period, for the purpose of any bonus only, 60 days following the first complete bonus year during the term. So on a no-show case, on someone who fails to comply with their contractual obligation to start work, we're looking at a period of the world that never was, the period when the term was running, but the guy never started work. We go back up the page to 12.3.1. We're looking at what was paid in that period. Answer, nothing, because my client was never paid anything. or agreed to be paid. So we're looking at what the contract says is agreed to be paid in this period that he never actually started work. And that is salary. Fair enough. We know what that is. And then any bonus paid or payable pursuant to subclause 3B, C, or D of your contract. And then upfront sign-on amount, well, I accept that's capable of being ascertained. There's an argument about whether there was one. Value of any benefits provided under clause 4. Got no particular point to make about that. But I do want to look at any bonus paid or payable pursuant to subclause 3B, C, or D. And those clauses we find back at clause 3, which is the bonus provision. Compensation is at page 19. Bottom of the page, you'll see 3, compensation. It starts on this page with salary.
Yep.
3B, C and D we're concerned with. 3B is during the initial period and any extension, the AT group, that's my client and anyone employed in the particular desk he's working on, will be eligible for a bonus which shall be equal to 49% of AT group net revenue less expenses. That's a bonus pool. And then my client will have discretion as to allocation of that bonus pool. If we go to the definitions for these purposes at 22, and we're concerned with AT group net revenue less expenses at 22.1, expenses is expenses incurred on behalf of the group in respect of salary, employment benefits, other employment remuneration payable, travel and entertainment, and at the bottom of the page, any other direct costs attributable to the group during the relevant period. And at 3, AT group net revenue means the collected commission revenue as determined by the employer acting reasonably in accordance with various things set out. And that's 3 lines from the bottom, generated by the AT group during the relevant period. So in order to work out what's payable, one has to work out on a hypothetical, on a counterfactual, as Mr. Sanders accepts, the relevant revenues that would have been generated over that period and the expenses of incurring them. And that's just on that item, we've got C and D to go, each of which involve hurdle questions of whether particular revenue thresholds would have been met to trigger the additional bonus. Now, the only way that those sums can be calculated, I mean, we actually say, well, they can't be calculated at all because nothing was in fact payable because none of this happened. But if the claimant's right that one has to go through a hypothetical exercise of looking what would have happened if my client had started over the period of the first bonus year if he had started, that's going to involve a detailed consideration of what the revenues would have been and what the expenses of earning them would have been, not just for my client, but for anyone else that would have joined the team. And once we're into that, you've got the whole trial of quantum and remedy all involved in that issue. If the claimants had wanted a quick and easy liquidated damages clause, they could have done it. They could have defined this in a different way without reference to what the actual bonuses would have been, but they didn't. And unfortunately, that means they're in for a bigger inquiry. And there's no point, Your Excellency,
Unless they simply contend, of course, the clauses 3C or 3B could have no operation in circumstances where employment didn't commence. That's a matter for them, I suppose.
Well, that is a matter for them. I mean, if they were to accept that the sums coming in that under those headings was 0, well, then we wouldn't need to get into it. But they don't. They reach their number by relying on some of these bonuses. And just one, I beg your pardon.
You go ahead. Sorry.
Just one final point. An important plank of Mr. Sanders' submission is to say, well, the exercise we're involved in at the first trial is a more broad brush, and we won't need expert evidence in relation to it till the second trial. But he accepts, as I've indicated, that there'll need to be factual evidence from witnesses of fact. The danger, of course, is the judge at the first trial is then looking at an issue with, on any view, any part of the evidence that is relevant to these issues, and is in danger of making findings of fact based on whatever level of granularity of factual evidence has been led, thinking if there's a second trial and experts get involved in this, there may be different answers to these questions. And that would be...
I understand that. That was the basis of my initial remarks to Mr. Sanders.
Yeah.
That's always the problem with this stuff.
Yeah. So, Your Excellency, those are my submissions on why a split wouldn't be appropriate.
Can I just ask this, and it may not be relevant at all today. You've pleaded that the liquidated damages clause is both a penalty and a unreasonable restraint of trade.
Yes.
I understand that means, in effect, you will have to show to make good the penalty proposition that the amount was grossly disproportionate to the damages. You're in one sense in the position of having to make that calculation as well. And the other thing I wanted to ask you is this, that does Article 120, you've also said it's an unreasonable restraint of trade. Now, minds might differ certainly between the United Kingdom and Australia as to whether this type of clause could constitute an unreasonable restraint, but leaving that to one side for the moment, would Article 122 have any effect on that?
I think it's a separate point, Your Excellency. I don't know what the position is in Australia, but I think as a matter of English law, and we say also as a matter of due by law, the restraint of trade question stands and falls on its own principles, unaffected by whether or not the arguments on Section 122 succeed or not.
No, our position is the same on that. Whether clauses of this nature do constitute an unlawful restraint is the issue as to.
Yeah, and there's a battle to be had about that point as to whether it applies or not.
But let's not go there today, if at all. Yes, thank you. Mr. Sanders, anything in reply?
Just one short point, Your Excellency, which is that Mr. Mansfield raises the question that if the judge at the first trial is determining the amount of the bonus sum without reference to the expert evidence, what he will be doing is an exercise with half the, or with part of the evidence, and with a view to potentially inconsistent findings between the first and the second trial. What I would just say about that is, once the judge at the first trial is determining the liquidated damages sum, the world we are in is a world in which there will never be a second trial. If a liquidated damages sum is being determined, necessarily we have won on the question that we are entitled to liquidated damages because it's a specified sum, and therefore the general damages inquiry that would take place at the second trial just never takes place. So there would only ever be one quantification of the damages. Either we're entitled to liquidated damages, in which case the first judge determines it, and we say is perfectly capable of determining it without expert evidence on the basis of the evidence that he would hear at the first trial, or the judge at the first trial says, no, you're not entitled to liquidated damages, and therefore there's nothing for him to quantify. He just says we go to a general damages inquiry, and that's a matter for the second trial. So I do say there's no risk of inconsistent findings there, or different determinations being made at the first and second trial. So it's important to...
The difficulty is there may be different evidence there. The judge, be it the same judge or a different judge, would have to determine all the evidence before him or her at that time.
Yes, and we say, but I say there's never a prospect of there being different evidence. What the judge at the first trial would have to determine is the amount of the liquidated damages on the evidence before him or her. And we say it's perfectly, given the nature of the inquiry, which we say, that's something which is determined on factual evidence only. But if the judge determines that liquidated damages are payable, even if they get reduced by Article 122.2 or however that works, there is never a second trial which takes place, because the second trial only takes place if the judge finds that the defendant is liable, but that we are not entitled to a liquidated damages award. So essentially, the most likely route through to that is the judge determines, no, it's not a specified sum because of the arguments that the defendants make. I would need to do a calculation, therefore it's not specified. Therefore, you're stuck with general damages. That's a matter for a second trial. But there's never a world in my submission in which the first judge is making a calculation with a sort of half an eye to the second trial, because once we're into the world where the first judge is making a calculation of the liquidated damages, we're into a world where the liquidated damages are payable, and therefore there's never a second trial. So there's only ever going to be one calculation of damages. We say that calculation is the calculation of the liquidated damages which are payable and will happen at the first trial. The defendants say, well, even if we're wrong on liability, the calculation is one that needs to take place as a matter of general damages, because the liquidated damages clause is not a specified sum, or is a penalty, or is in restraint of trade, what have you. Therefore, you fall back on general damages. But we're never in a world where we're going to have two calculations of damages on the basis of different evidence. We'll only ever have one.
Mr. Sanders, I'm not minded to order a split trial. Having regard to the issues involved, I'm not satisfied that any benefit in making such an order outweighs the risk of duplication in the two. If such a order was made. Now, if the parties want to, I'll give more detailed reasons, but they can let me know that in due course. I won't be able to give them for a few weeks, but that's the view I've taken, and I dismiss the application.
Thank you, Your Excellency. That then feeds into the what we do in terms of the case management order.
What about cost of this application?
Well, not a matter for me, as I understood it. The parties, in terms of the case management order, had said that this application was costing the case, and as I had understood it, that's a matter which is agreed. But see if Mr. Mansfield is saying something different, then it's his application to make.
Well, Your Excellency, I don't have there's force in what Mr. Sanders said. We needed this hearing for cost management purposes anyway. I'm not currently instructed to sort costs in relation to this. So costs in case is what's in the draft.
I'll make that order to the extent necessary.
I'm grateful, Your Excellency. Sorry, Your Excellency, I cut you off.
So which case management order should I work off? There's two alternatives, I think.
There's in the bundle at page 91.
Thank you.
Is, I believe, the effectively agreed
thank you.
Case management order. Paragraphs 1 and 2, which are in square brackets, obviously can now be deleted because they deal with the split trial application, the production of documents at 3 to 9 remain agreed, don't require amendment in relation to the outcome of the split trial. Witness statements, the same. We don't ask for them to be pushed back. Paragraph 13 in relation to expert reports, you'll see the defendant's comment there that paragraph 13 will be required in terms of a direction that parties apply for permission to rely on expert evidence, and that's required if there's not an order for a split trial. Well, Your Excellency, obviously you haven't made an order for a split trial, so paragraph 13 of that numbering is included within the case management order, and as far as I'm aware, that's agreed between us. And then we're pre-trial review. Obviously, that date needs to be confirmed, but that'll flow from the listing of the main trial bundles at 15, 2 weeks before trial. Again, that can remain as is because that stems from the listing of the trial reading list and trial timetable agreed, save for inserting a date. Same with skeleton arguments at 17 and 18 and chronology. So then we're at paragraph 19 in relation to the trial, which is just dealing with listing and an estimated duration. Now, the defendant in its case management information sheet suggested that a single trial of this matter would be 5 to 6 days. As I prefaced,
I thought it was 5 days of the day's reading time. So if that be right, it's 5 days.
Well, I'm not gonna get too much into it. We say it's not a particularly document heavy case. It probably would only need half a day, 5 days, but I'm not gonna, I'm not gonna quibble about that. So too much. So be it. But certainly in terms of hearing time, we would say it's no longer than 5 days. And it could possibly, it could possibly be 5 days to include pre-reading, but I'm not going to push one way or the other on it.
Let's just work on the basis 5 days. If it finishes earlier, that's so much the
better. In terms of listing for trial, the defendant has indicated that it would be ready for trial from the 6th of April. Now, the 6th of April itself is Easter Monday. I appreciate it's not a bank holiday in the Dubai courts or in Dubai, but for the claimant's part, Your Excellency, we would seek to avoid the Easter weekend itself. So we would be looking at the 13th of April as a week. Subject, of course, to the availability and listing of on the Dubai end.
I have a difficulty that week. Is it going to cause a problem to the parties if we commenced it on Monday, the 4th of May?
Your Excellency, I'll just take instruction. I doubt it, but the only point that comes immediately to mind is that in the UK, the Monday the 4th is a bank holiday.
Tuesday the 5th. I don't just say the week commencing the 4th of May, or I could do it the following week.
That'll be the week of the
11th.
Can I just take instruction?
Yes.
Yep, that's fine on our side.
Your Excellency, can I just check with you that having said that the 13th of April doesn't work, am I to take it from your proposal of the 4th of May that the weeks of the 20th and 27th also aren't convenient?
I have difficulty those weeks, yes.
If you just give me a moment, Your Excellency, to take instructions. Either of those weeks have Right,
Well, let's
11th
make
of
it.
May.
Well, let's make it the week commencing the 11th of May then. Now, there's no need necessarily to decide this yet, but should it be virtual, online, or live? One thing that may be relevant on that is that I think it was the claimant who said that there's a possibility a number of witnesses will be giving their evidence virtually as distinct from live. It'd be not necessarily the most economic course if we all flew over to Dubai then to take evidence online from a whole series of people who aren't there.
Well, Your Excellency, I quite agree, and for our part, we would propose a virtual, a remote hearing in full rather than in person or hybrid.
Your Excellency, we prefer an in-person trial. My client's based in Dubai. He's the guy that's being sued. It's quite a complex case. For a case of this length, we say it's more suitable for an in-person hearing than remote. If there are particular reasons for that the claimant has difficulty with witnesses attending in person, they can make an application in relation to that. But I don't think I've seen anything specific about that as yet.
So, Sanders, I certainly would prevent you from having witnesses, particularly expert witnesses, give their evidence online. But having regard to what Mr. Mansfield said, and what I understand the policy of the court to be at the moment, it's probably preferable to set it down for a live hearing, I think.
Well, Your Excellency, as I say, our preference is virtual. It saves everyone the cost of we have four London Council in this case. It saves everyone the cost of flying everyone out to Dubai and costs of that. We say that the majority of the issues in this case are legal. We say it's appropriate for a remote hearing. Ultimately, of course, we're in the court's hands, and we'll do whatever you order. But those would be our submissions on it.
I'll set it down for a live hearing. I think there's force of what Mr. Mansfield said. His client's in Dubai, and he's the person being sued, of course. But if, when the evidence emerges, it turns out that it really is an arid exercise to go to Dubai, then I'll certainly be prepared to review that decision. It doesn't have to be set in stone.
I'm grateful, Your Excellency.
Well, that means paragraph 20 will be the 11th of May with an estimated duration of 5 days. What about a pre-trial review? When do you propose
Just trying
that?
to do the maths, but I think we had proposed 28 days beforehand, which would take us to the 20th of April would be our proposal.
Mr. Mansfield, what do you say?
That seems sensible, Your Excellency, subject to the court's convenience.
I could do that. I don't want to get you two up too early in the morning, which is what I've done today. If I set it down for 5 p.m. Sydney time, which is, I think, 12 noon Now, what I'll do is, rather than try and fit around the days, I'll set it down for 12 o'clock Dubai time, which I think is a bit better for you than 9 o'clock Dubai time.
Extremely grateful, Your Excellency.
You won't get the same indulgence with a virtual hearing, though. Very well. I'll set it down for 12 noon Dubai time on, what day did we say?
The 20th of April.
So it's order 14. Very well. That order will be made and dealt with by the registrar and sent to the parties. Is there anything else at this stage?
I think, Your Excellency, there are just a couple of TBC dates for 16 reading list and 17, 18 skeletons and the like. Mr. Sanders will tell me if I've missed anything. I think it's just those paragraphs.
16, 17 and 18, yes.
Yeah.
Provide. So,
well, why don't we make all of them the Wednesday of the preceding week?
Yes, Your Excellency.
That would be the 6th of May, I think.
The 6th, yes. There's a slight oddity, Your Excellency, in the language at 16, which says no later than 2 clear days before trial and in any event by no later than. If we're fixing 6th of May, we could perhaps just delete that 2-day language.
Yeah, agree.
I have nothing further. Thank you, Your Excellency.
Nothing further from me either, Your Excellency.
Well, thank you very much. And as I said, I'm sorry to have got you up so early in the morning. If I'd realised you were based in the United Kingdom, I would have changed the time at least for the day. But please accept my apologies.
At all. Thank you.
Thank you. Thank you. I'll adjourn.
Good morning.